What we're going to talk about today is the topic of alternative dispute resolution, and in particular focus on some recent practical developments which may impact on the need to engage in forms of alternative dispute resolution within the courts. So historically, when you talk about alternative dispute resolution, we really think about it in terms of an alternative way of resolving disputes other than going before a judicial officer. Many people historically have said, well, effectively it's resolving disputes without recourse to the courts and different means. More recently, however, what we've seen is greater pressures both from the courts and the legislature to adopt forms of alternative dispute resolution within the context of litigation itself in order to be able to resolve matters. And in particular, this is driven by the view to reduce costs to the court system. I had a look at a paper, it's not up to date, but it was 2008, 2009. $300 million went into the federal court, the federal magistrates court, and the family court. And the total of the gross Commonwealth Justice System budget was over $1 billion. So that's a very expensive way to deal with disputes within society. What this paper will do is provide a brief overview of the main forms of ADR processes, talk a little bit about their benefits and limitations, look at these recent developments in the courts and changes to Commonwealth legislation, and finally just raise some practical drafting issues that you can consider. What we'll do then is finish up with a brief discussion from Megan on a very practical change in New South Wales law recently, which will impact upon people witnessing statutory declarations and taking oaths, which is something we all should be aware of.